Introduction to the Legal Effects of Contracts. Last lesson, when we talked about contract elements, we assumed that an agreement that had all the essential elements would be a valid and enforceable contract. But that's not quite the whole truth. Some contracts that appear to be technically valid are not enforceable and have no legal effect. In this lesson, we'll talk about the legal effects of valid contracts and how contracts can become void and unenforceable. Let's start with a story. Imagine Tanya and Terry make a deal. Tanya offers to sell Terry her house for $200,000. Terry tells Tanya he needs to borrow money to pay for it, and he's worried he might not qualify for a loan. He's also concerned about the old furnace in the basement, which doesn't work well. Tanya agrees to give Terry time to find financing, and if he can't find a loan, she'll let him out of the deal. In the meantime, she agrees to replace the furnace. Terry agrees. They set July 1st for a closing date, draw up a purchase and sale agreement, and sign it. Okay. Tanya and Terry have a contract. But just what does that mean? What's the legal effect of having a contract? Duty to perform in good faith. First, Tanya and Terry owe one another a duty to perform their obligations under the contract. Terry promised to seek financing so he can pay Tanya $200,000. Tanya promised to replace the rundown furnace. They also agreed to close on July 1st, which means each of them have tasks to perform in order to be ready by closing day. Terry has to find a $200,000 loan, and Tanya has to replace the furnace. If either of them fails to perform, then they can't close on July 1st. Before they made their contract, Terry and Tanya owed one another nothing. Either could have walked away from the deal without any consequences. They had no obligation to one another and no reasonable expectation of receiving any benefit from the proposed deal. Without that contract, Tanya's hope of raising $200,000 from the sale was just a dream, and Terry's daydreams about a home with a warm new furnace were just idle fantasies. Making a contract changed Terry's and Tanya's hopes and dreams into reasonable expectations of getting either a house or $200,000. The contract now binds Terry to Tanya and Tanya to Terry, and each has the right to expect that the other will perform the promises made. The law calls this mutual obligation a duty of good faith and fair dealing. The law expects Tanya and Terry to work in good faith to perform the contract. If Terry doesn't submit a single loan application, then he is failing to perform in good faith. If Tanya doesn't replace the furnace before July 1st, or she goes down to the basement and spray paints the old furnace to make it look new, then she is failing to perform in good faith. The duty of good faith and fair dealing is intuitive. Tanya expects Terry to make a good faith effort to secure financing, and Terry expects Tanya to replace the furnace. If you were in either of their shoes, wouldn't you? When a person doesn't even try to perform their end of a bargain, we naturally feel the other party has behaved wrongly. Courts feel the same way. If asked, courts are likely to rule for a party who performs in good faith and rule against a party who performs in bad faith. In the overwhelming majority of cases, parties to a contract perform as expected, and the contract completes without a hitch. It's not a mystery as to why. In most instances, both parties want to perform their obligations under the contract, because each believes they are getting the better end of the deal. If Terry did not want to pay $200,000 for the house, then he would not have agreed to buy it. Similarly, Tanya must prefer $200,000 in cash to keeping her house. The possible reasons for why Terry and Tanya feel as they do are as varied as human experience can provide. Perhaps Terry has been living in an apartment next to a drummer, and he relishes the peace and quiet that Tanya's home provides. Maybe Tanya has decided she's tired of living in one place, and she wants to sell her house and travel the world. The possibilities are endless. The bottom line is that each party to a contract, for their own reasons, believes he or she will be better off if the deal happens. A belief that a deal is in your own best interest creates a natural pressure to perform. Court involvement, interpretation. But not every contract goes smoothly. Sometimes the parties disagree about what the contract requires. Other times, one party believes the other has failed to perform his or her obligations under the contract. We call a failure to perform a breach of contract. When parties disagree about a contract's meaning or believe a breach has occurred, courts can help resolve the dispute if the parties ask for help. Court involvement is another important legal effect of a contract. If the parties believe they have a contract, then either party can bring a legal action to court, asking the court to interpret or enforce the contract. The court will hear the dispute and help the parties resolve it. You might wonder why a court would have to interpret a contract. When we talked about the essential elements of a contract, we said that an offer had to be clear enough for another party to accept the terms of the offer. If the parties have made the essential terms of the contract clear, what's left to interpret? When you stop to think about it, it's easy to understand. Parties don't plan for every eventuality. Let's go back to Tanya and Terry. Imagine Terry tried to find a loan, but the only loan he could get was at an interest rate 5 percentage points above the going rate for mortgage loans. Frustrated by the above-market rate of his loan, he tells Tanya that the deal is off because he can't find financing with a good rate. What will Tanya do? Tanya might say to Terry, "Hey, we agreed that you could only get out of the sale if you couldn't find financing. But you did find financing. You just don't like the rate you got. You're obligated to take that loan and close on the deal. I'm not letting you out of our contract." Terry might reply, "When we agreed on the financing condition, we were obviously talking about a reasonable loan. Surely you don't mean I have to take any loan available, even if the interest rate is absurd." Who's right? As you can see, they both have a point. Should Tanya be able to force him to borrow money at such a high rate? This kind of uncertainty can easily arise in any contract, particularly when the parties overlook things that might happen. When Terry and Tanya were talking about financing, their top concern might have been whether Terry would qualify for a loan at all. The possibility that Terry might qualify for a loan that Terry found unacceptable might not have crossed their minds. In situations like these, the parties may call upon a court to interpret the contract, and the court will try to fill in the gaps that the parties had not expressly addressed. Court involvement, enforcement. A court's ability to enforce a contract is another important legal effect of having one. It is a major reason people make contracts. Knowing that if your contracting party fails to perform, you can ask a court to enforce the contract is comforting. A court can enforce a contract in two major ways: by awarding money damages or by ordering specific performance. In most enforcement actions, the court awards expectation damages. An expectation damages award is a money award that puts the non-breaching party in the same financial position she would have been if her expectations had been met. That is, if the breaching party had performed as promised. Suppose Terry breached his contract by failing to seek financing, and Tanya sold the house to someone else for $180,000. If Terry had performed as he promised, Tanya would have gained $200,000 from the sale of her house. From Tanya's point of view, Terry's breach caused her to lose $20,000. The sale of her house brought her $20,000 less than she expected, based on her deal with Terry. Tanya could sue Terry and ask the court to award her $20,000 in damages, which would place her in the same financial position she would have been if Terry had performed. Her expectations of receiving $200,000 from the sale of her house would then be met. Although a court awards other kinds of relief in a contract case, expectation damages are the beating heart of contract actions, and the goal of the court is to make sure that the non-breaching party gets the expected benefit of the contract. Sometimes, though, money damages are not enough to compensate a person for the breach. Cases involving real estate are like this. No piece of land or house is exactly like another, and although the seller may have only been seeking money, the buyer wanted to own that specific property. Sales contracts for other unique items like art, custom objects, or items in short supply are also situations where money damages might not be sufficient to meet a party's expectations from the contract. In these cases, the court may grant specific performance, which is a court order directing a party to do specifically what is required by the contract. If Tanya announced at closing that she had changed her mind about traveling the world and refused to sell, even though Terry had brought the money to closing, Terry could ask the court for specific performance and require Tanya to complete the sale. Valid contracts. So far, we've been talking about the legal effects of a valid and enforceable contract. A valid contract is a contract that has all the essential elements of a contract: competent parties, offer and acceptance, consideration, mutual agreement, intent to create legal obligations, and a legal purpose. If an apparently valid contract is unenforceable, it's usually because it's missing one of these elements. Once a valid contract goes into effect, the law imposes the duty to perform in good faith, and the courts can interpret or enforce the contract if the parties ask it to. Executed and executory contracts. What happens when the parties have completed all their obligations? Does the contract have any further legal effect? The answer is usually no. When both parties have completely performed their contractual obligations, we call their contract an executed contract. The court will not impose any legal obligations on a party to an executed contract, because the parties have already done everything the contract required. the court cannot require them to do more. Executed contract is easy to remember because it sounds like the contract has had its head chopped off, which it has, in effect. The courts will no longer enforce an executed contract because the parties have fulfilled all their contractual obligations. However, if the parties do have significant obligations left to perform under a contract, then we call the contract an executory contract. Now, executory contract is not as easy to remember as executed contract. Executory just doesn't have the same ring as executed. But to help you remember, I'll say it again. An executory contract is a contract in which one or both parties have not yet completed performance of their obligations. Usually, it's easy to recognize executed contracts and executory contracts. But sometimes, particularly in real estate, it might be harder to make the right distinction. Let's add a fact to Tanya and Terry's story. Imagine that Tanya has a mortgage of her own with XYZ Bank, and she still owes $120,000. As part of their contract, Terry and Tanya agree Tanya will pay off her loan from the proceeds of the sale and have XYZ Bank record a discharge of her mortgage deed in the land records. Closing goes off without a hitch. Terry has found $200,000 and Tanya has replaced the furnace in the basement. Terry gives Tanya $200,000. She writes a $120,000 check to XYZ Bank, keeps $80,000 for her, and gives Terry a deed. Are they done? They would seem to be. Terry has a deed, Tanya has $80,000 for her world travels, and XYZ Bank is paid. Everyone's happy. What else is there to do? Well, Tanya still has to get XYZ Bank to discharge the mortgage. If XYZ Bank doesn't record Tanya's mortgage discharge, then it's going to cause headaches if Terry tries to refinance or sell the house, because Tanya's mortgage will still show as valid in the land records. Tanya and Terry's contract is still executory because the mortgage discharge has not been recorded. After XYZ Bank records the mortgage discharge, Tanya and Terry's contract is an executed contract. They no longer have any legal obligation to one another. Terry can move in, and Tanya can travel. Let's talk now about void contracts, voidable contracts, and unenforceable contracts. These contracts have characteristics that render them either entirely unenforceable or only partially enforceable. Void contracts. A void contract is an agreement that has no force or effect and is legally unenforceable. An agreement can become a void contract in two ways. It can be void when the parties make it, or it can become void when something happens to render it void. Let's start with the first case, an agreement that's void when it's made. A contract is usually void because it lacks some essential element. For example, a contract can be void because it has an illegal purpose. One common example is an agreement between a supplier and a dealer to provide illegal drugs. The supplier and dealer may have bargained extensively to reach a deal beneficial to both of them. They may even have an exquisite delivery schedule mapped out and thought of all sorts of contingencies for compensating one another if things go wrong. But as a matter of law and public policy, the court simply will not enforce the illegal drug supply agreement, regardless of how well negotiated it was. The agreement is considered void the moment it was created, because it was created for an illegal purpose. Remember our hitman from the last lesson? His contract too failed because it aimed to perform an illegal purpose. An illegal purpose can be a little harder to see, yet still render a contract void. Imagine Tanya was a renter. She didn't own the house, but she offered to sell it to Terry anyway. In this case, the agreement between Terry and Tanya would be void when they made it, because it's not legal to sell someone else's property without their permission. If Terry tried to sue Tanya for breach of contract, the court would not enforce the contract or award damages because the agreement was a void contract. Now, Terry might have a separate fraud claim against Tanya, but that's another story. An otherwise valid contract can also become void because of a change in law or circumstance. Imagine Max makes a contract to sell Beth a rare South American monkey and deliver the monkey in 6 months. If 3 months into the contract, their state passes a law prohibiting the sale of the monkey because it was granted endangered species status, the contract will have become void because what was once a legal purpose had become illegal due to a change in law. Voidable contracts. Don't confuse void contracts with voidable contracts. Voidable contracts are otherwise valid contracts that can be avoided, usually by the choice of one of the parties. You may recall we talked about voidable contracts last lesson, when we said that parties must have legal capacity to enter a contract. Minors, mentally ill persons, and intoxicated people can enter into contracts with others, but the contracts are voidable. If the minor, mentally ill person, or intoxicated person chooses to avoid the contract, the court may decide the contract is void and unenforceable. Remember, the choice to avoid the contract lies with the person who lacks legal capacity. If the person lacking capacity decides to go ahead with the contract remains enforceable against the other party. Other circumstances that can create voidable contracts are agreements made under duress, undue influence, fraud, or physical threat. In each of these circumstances, we feel that the unfair treatment of one party provides the wrong party with the opportunity to avoid the contract. Finally, one other voidable contract is the unconscionable contract, a contract that no reasonable person would agree to and no honest person would expect to make. Imagine, for example, an art expert is browsing the stalls at a flea market and comes across an original painting by Van Gogh, offered for sale by somebody who is completely unaware of art or Van Gogh. The art expert asks the seller how much he wants, and the seller offhandedly shrugs and says, 50 cents. The art dealer exclaims, "It's a deal." He snaps up the painting, tosses $1 to the seller, and leaves the flea market. The painting is subsequently valued at $20 million. The agreement between the art expert and the seller is arguably void because it is unconscionable. The art expert, who knew the value of the painting, received a massive windfall due solely to the seller's ignorance of what he was selling. If the seller wished to sue, he would stand a fair chance of recovering the painting because the contract was unconscionable. Unenforceable contracts. An unenforceable contract is an agreement or contract that is unenforceable. We've mentioned quite a few unenforceable contracts in this lesson already. Many of them, like the voidable contracts, are valid contracts that one of the parties makes unenforceable by exercising an option. Others, like the illegal drug supply case, may include all the essential elements of a contract, but are unenforceable by operation of law. Another example of an otherwise valid contract rendered unenforceable by law would be an oral agreement for the sale of real estate. The parties may have agreed on every detail, price, conditions, closing date, and yet still the contract would be unenforceable because it was not written and therefore violated the statute of frauds. In all of these instances, when a court deems a contract void or unenforceable, the party's legal obligation to perform ends, and the parties lose access to the courts for contract enforcements. Such contracts have no further legal effect.